is still, although the redemption period under the rules has now been reduced to 60 days, and true, a judicial sale can be converted back to foreclosure if there isn't enough equity, so you don't have to go through a judicial sale if there isn't any equity. Still, it's a long, tedious, expensive process and should only be undertaken when these circumstances I mentioned are primary. The real distinction between foreclosure and sale is the question, as I always put it, is a question of accountability. If under judicial sale and foreclosure, the courts take the responsibility for the process and the mortgagee is not accountable. In the power of sale, it's a self-help remedy, and he is accountable for the process and for the result. So that the upside is that it's quick for power of sale. The upside is that you can sue for a deficiency, but you are accountable for, as I say, the process and the amount of the realization. With foreclosure, you get title, and if you sell, you're not accountable. When you sell, you take the profit or assume the loss. You can't sue for a deficiency if you foreclose and sell. And I say to you, the reason why you can't is that you can't sue for the deficiency because you're not accountable for the profit. The mortgagor is not accountable for the deficiency. The kicker here is that if you cannot be accountable for the property, you can't sue for the deficiency, and that means you must be accountable for all the property. So that if you foreclose 20 lots and you sell one of them, once you've sold and you can't return the debt, you can't return the security, you can't claim on the debt any longer. So you've got to be able to return all the property on redemption. So you can't foreclose and sell one smidgen of the security, and once it's gone, you've lost your right to claim on the debt. You've accepted the property in satisfaction of the debt. Now, I've given you in Schedule A nutshell summary of the advantages and disadvantages of foreclosure and sale in the rest of the features between the two remedies, and you can just glance over them and you'll see that you'll see the various disadvantages and advantages, but I've essentially given you the prime ones. The most critical factor, I think, in terms of the problem with foreclosure, in terms of a step which you may regret taking, and that is that once you start a foreclosure action or a judicial sale action, the court gets seized of the property and you can't back out. You've got to go through with the process. It's very hard to discontinue or abandon that process. And any of the parties that join in, for example, if you act for a second mortgagee and you put in a DOR, desiring opportunity to redeem, or a request for a sale, you're locked into that action. And you can't later exercise your private rights of power of sale without leave of the court. And a recent decision has said you have to give compelling reasons to get permission to sell under power of sale once you've participated in a judicial action. So that from a subsequent encumbrances point of view, you'll have to think carefully when the first mortgagee issues a foreclosure writ whether you're going to put in a DOR or a DOS, because you might be locked into that action and your power of sale is gone. Now I'm going to turn to the power of sale, and we're going to walk through that checklist I had. Run through, Frank tells me. Okay. Well, I'm going to touch upon the things that. Well, I learned a new word this winter in skiing. It's where you go over the lip of a hill and you suddenly see the hill drop, danger ahead of you that you never expected, and the adrenaline comes through your body, and you say, "Yikes!" And I'll try and go through this and give you the yikes words as far as power of sale is concerned, because there are many times, although you can never lose a foreclosure action or a sale action, you never lose it. By being delayed and having your process really screwed up, it's like a loss because the cost can be enormous in messing up an action. Now, or a process. And it's when later down the line, when you're ready to complete a sale, and all of a sudden one of these issues comes up and you go, yikes. And you may have to go right back to the beginning. And so let's touch on them. If you look at the checklist, there's one item that I'm going to say before you even start the checklist, and that is conflict of interest. It's something that we're becoming more and more aware of, and that is if you've been a solicitor for a mortgagor and a mortgagee, in other words, you've acted in the usual course of putting on a mortgage, for heaven's sakes, don't act for the mortgagee then suing that mortgagor. He was your client, and even if he is peripherally a client, you acted for the lender and the mortgagor came into your office and signed the documents, or you had some contact, and you may have even issued an account addressed to that mortgagor. Don't act against him because you can have that there's been actions where a mortgagee has been enjoined from proceeding until he changed solicitors. The solicitor has been enjoined, or you certainly won't get costs against him. So I think you should be wary of that. Now, let's deal with number 2, document inquiry. I think that's probably one of the most critical elements. One of the advantages of power of sale is saying, well, you can issue it right away. You can instruct the solicitor and he can issue it the same day. Subsearch the title quickly and issue it. Yes, it can be done, but I think it's most inappropriate to issue it that quickly. I think you should examine the documents and make the inquiries because it's on one of those quickies that you're going to find out later that there may not even be a power of sale in the mortgage. With a lot of crazy standard charge terms around, you might very well find that somehow they've missed a power of sale clause in the mortgage. Or the power of sale clause may have a peculiar time limit. I once issued one several years ago. It was for a Canada Trust, and a doctor had abandoned, it was one of these overbilling doctors with OHIP, and he abandoned the country. And it was in the papers that they saw him leaving the docks and he's gone, and he's left the country, and they instructed me, well, he's gone, let's issue power of sale right away. And I did. And then going for the sale, completing the sale documents, I look at the mortgage and it has a 30-day default in it. And I was stuck having issued a power of sale 18 days after the default, and it had a 30-day period in it in the mortgage. And that was a sort of a standard Canada Trust mortgage at the time. So you just can't assume that all mortgages are going to say, on default of payment of 15 days, the mortgagee may enter and sell, and so on. You got to look at that mortgage, and today you've got to track down the standard charge terms. It's not in the registry office, so you're going to have to look at it, and I implore you to do that because you may be caught off guard later down the line. And that goes with any particular address. You've got to ask your client, have you got any correspondence with the mortgagor? Because you may find that there's notices or letters that he's changed addresses. You've got to make those inquiries. So it's very important to do that. Because as you know, if there isn't a power of sale, you're going to have a 45-day period rather than a 35-day notice. Default, that's number 4. The default has to be 15 days under the Act, and it could be longer, as I say, under the mortgage. But make sure that if the default is a default other than payment, breach of covenant, waste, all that stuff, you've got to give notice of the breach and allow some time to run before the 15 days default even starts. So that you can't just issue a notice of sale on a default of breach of covenant. You've got to give a further notice to advise the mortgagor of the default to create the default that is required to issue notice of sale. Where you've got a demand mortgage, and this is becoming more and more common under the current state of the law, Lister case, you've got to, and all that follows it. I think you can't create a default by a demand without giving a reasonable demand. And that reasonable demand is going to have to be based on the circumstances of that particular loan. So that you certainly can't say, I'm going to demand you pay me by tomorrow by noon and issue notice of sale 15 days later as the default having been created. You may very well have to give a 10 days demand before the 15 days runs for issuing notice of sale. Now, let's go to 14. I'm going to skip right over to 14. Corporate mortgagor. This is a yikes matter. You can issue a notice of sale against a mortgagor, but I would corporate mortgagor, but I'd certainly search very quickly after you've issued notice of sale to make sure that the corporation is still in existence. I just had one just now as a foreclosure action, and this firm got way into the action down to a reference, and when it was found that because the principal of the company was still dealing with everything, but the company had been escheated, the property had been escheated to the Crown. The corporation had its charter canceled, and the whole thing was just a nullity. So that the public trustee had to be added, and we had to really start back to square one. So it would be very embarrassing when you're trying to complete a sale at the end of the process to find that the corporation wasn't in existence. So you should really check that out. Number 15, a guarantor. Always serve a guarantor. You don't have to serve them, but what's another 36 cents or whatever to send out the notice to them. Let's go to 18, the preparation of the notice of sale. Now, you've got a statutory form, but the printers have tended to embellish the statutory form, and we tend to buy the forms and follow the printed forms, which may or may not be accurate. So when you have a problem in trying to fill out the form and you're concerned about how do we fill this out, you may not even have to fill it out. Go back to the statutory form. I had an instance a couple of weeks ago where I got a call saying, we've got a floating rate. So how do we fill in the demand that says we demand you pay this much and interest until the date of payment at the rate of and costs? How are we going to fill that in? We don't know what the floating rate will be during the demand period. I said, you don't have to, because the statutory form says the amount now due is. And that's all it says. There's no requirement to fill in what is the rate during the demand period. The amount now due is. And that's what you have to put in the statutory form. I said, forget it. Just put in now, and what has to be redeemed later if they're going to pay up will be dealt with as the amount required to be redeemed or reinstated. You don't have to set that out. So, yes?
I'm just curious about one point, sir. With respect to the existence of a corporation,
yes,
mortgagor, how can a company be in existence, not be in existence, if it still owns property subject to a mortgage? I don't understand how that would work.
Well, the company is registered on, the company is shown as the registered mortgagor, yes, the registered owner. But if its charter has been canceled, under the Escheats Act, the property gets escheats to the province. And the Crown then becomes the owner of the land. That's right. The public trustee is the one who administers that. And so that in order to get it back, there'd have to be an application for a reinstatement and a quit claim from the Crown. And there's usually it's done via a cabinet order. So it's a process you have to go through that may take maybe 3 months to get the.
More expedient just to go after the guarantors.
Well, if that's part of if the guarantors are as a mortgagee, you still have security over the property. you have priority over the Crown. It's just that your procedure in selling may have been inaccurate. Your security isn't affected because you still have priority over the Crown. Takes the property subject to all the existing debts against it. So your mortgage is intact. Okay. Let's go to 16. I think you should be aware that today you've got the Farm Debt Review Act. So if you're dealing with farm property, you've got to give the appropriate notice under the Farm Debt Review Act. Otherwise, your notice of sale is, you just can't, it's a restraint on proceedings. So that I just point that out to you so that it triggers in your mind that if you've got a farm property, call up the Farm Debt Review Act Review Board. Their head office is in Guelph, and they got a phone number, and they'll send you a lender's brochure. And yes. Oh, I see. 10. Go ahead.
Sometimes there's legislation that allows the building code act allows the city to go in and do some work related to the property. And I think it says add the cost of that to be collected when tax. Does that make that amount, does that
Have priority to the mortgage? Well, there's a whole series of decisions dealing with that issue as to whether that's, you can look it up under the heading Crown liens, and there's a whole series of decisions to try and determine whether the statute in creating that lien creates a true lien as taxes, or merely uses the tax rolls as a collection device. So if it says it's deemed to be taxes, like the PUC in Ontario, PU says it's deemed to be taxes, then it'll achieve the same priority as municipal taxes, which has priority over mortgage. If it just says it can be added to the tax rolls and collected in a like manner as taxes, I think the jurisprudence says that that's not strong enough language to give it priority as taxes. So I think you're going to find that's the criteria. So you have to look at the, okay? Now, farm property. Let's go to 18 after farm property. Preparing notice of sale. Now, again, I mentioned to you that the deviation from the statutory form. If it says principal, interest, there's a heading for principal, there's a heading for interest, there's a heading for other amounts, insurance premiums you might pay. You've got to deal with all those items separately. There's a decision where a mortgagee lumped it all together and just quoted amount now owing. The notice of sale was held invalid. Also, check that your addition is correct. There's a decision where there was a transposition of figures, and the total on the mortgage was about $20,000 more than what was actually owing. It was held, the notice of sale was invalid. Another decision where it was just a less than 1% deviation and it was claiming less than what was owing, it was held not to be invalid. There was one decision where the printed form gave an alternate phrase, to strike out the inapplicable words, and the person didn't strike out the inapplicable words. The mortgagee was held that notice of sale was invalid. So you've got to prepare that notice of sale with care, and don't try any fancy words. Fill out the form. It's meant to give notice. It's a statutory form. You don't have to give any more than the statute requires. Okay, sorry. Fast forward. Okay. The demand date, I just indicate to you now it's 35 clear days. That's pretty well the position. That means counting day 1 as the first day after you issue the notice of sale, and 35 as the final date, give 37 days. So you've got a clear 35 days. Now the Family Law Act has made it clear that the Mortgages Act prevails. so that you don't have to give any extra days for a spouse. Parties to be served. I've pretty well listed all the people that have to be served, but all I can say to you is when in doubt, serve. There's no harm. You're not going to be faulted for serving any extra notices. Time and manner of service. The biggest pitfall is blithely going ahead and addressing a bunch of notices according to the substantive title without care as to what I said in the beginning, as to find out whether the mortgagee has had any correspondence with the mortgagor. Check the phone book. There may be a new address. There's just a recent decision where a second mortgagee issued a notice of sale, and it came back. I'm sorry, the first mortgagee issued a notice of sale to and sent it to the second mortgagee and to his lawyer's office as shown on the mortgage. The notices came back. Now normally, you don't have to worry about notices coming back. If they're not served, you still sent them out by registered mail, and that's good service according to the Act. But in this case, the mortgagee did nothing to check out why they weren't served, why they came back. And it turned out that the lawyer's address had changed. The firm had changed, and there was now there was a different address in the lawyer's directory and in the phone book for that firm. Also, the second mortgagee's address was listed in the telephone directory, and it wasn't the same as on the instrument. And the mortgagee was criticized for that kind of service. It was part of a larger decision, but it indicates that you can't just in a pro forma way, have clerical people just address the notices of sale according to the subsearch. Remember, it's the last known address that is really the address to be served of everyone. So you've got to find out what is the known address. After the notice is given, go on to that. After the notice is given, the biggest pitfall is Section 40 of the Mortgages Act that says that while the notice is given, you can't do anything during the demand period. That means you can't take any action, you can't take any advertisement, you can't take any action for possession. You must remain absolutely passive. Otherwise, the steps that you're going to take may be invalid. Now I'm whipping along. Preparation to sell. Can I mention a bit about standard of care, or am I out of time? Power sale? All right. Standard of care. There's been a lot written in the last 10 years, and there's a lot of jurisprudence on standard of care of selling. In fact, Frank Bennett has just recently given a special lecture on this subject alone, just a month or so ago in the Law Society Special Lectures, or rather a large review of this area of law. And there's been a lot of statements by judges, and there's been a lot of analysis of how the property should be marketed. I'm going to boil it right down to you because I think it can be boiled down, notwithstanding Frank's lengthy paper. The courts are imposing a requirement that the mortgagee must take reasonable precautions to obtain the true value of the property. We're not quite sure what true value is. They haven't defined it, but it seems to be fair market value. And what is reasonable precautions? Reasonableness implies negligence if you fail to meet that standard. So we've got really an imposition of avoiding being negligent in disposing of the property. Now, what do you do to not be negligent? You first got to know what you're selling. And when you know what you're selling, you find out what its criteria is. The leading case of Cuckmere brick that came over from England was where they advertised property as single-family lots, and they neglected to advertise that it was also available for multifamily use. And the mortgagee was held negligent in offering the property for sale, and damages were awarded against the negligence, so that they didn't advertise what the nature of the property was. Also, you've got to know what the value is, and that is getting decent appraisals, not windshield wiper appraisals, because the appraisers will be later held to account for their views if you get into an issue. So get a good appraisal or as much good evidence as you can. Because what it turns out to be when there's a fight about whether you didn't sell it right is to find out what the true value you should have sold it for, and that's based on the battle of appraisers. Really, if you read the decisions, what you're finding is a court listening to the various appraisers and then making a finding of fact of what the true value was at the time it was sold. And he'll say, I like this appraiser, I don't like that appraiser, I think this appraiser was too high, this is too low, he didn't examine it right, and so on, and say, because you get a range of appraisals. For example, in the Wood and Bank of Nova Scotia case, the mortgagee had a $45,000 mortgage, had a $50,000 appraisal as to value, sold it for $45,000, and at the trial there was appraisals going right up to $95,000. And the court says, I find the true value $65,000 and awards $20,000 damages against the bank. So the appraisal evidence is fundamental to a sale. Secondly, there may be some obligation now on a mortgagee to do something to spruce up the property and make it saleable. Usually a mortgagee doesn't have the obligation to lay out money out of his pocket, but there may be creeping into this negligence concept and a requirement to do something, to clean away the junk from the front porch or put a coat of paint on it or something. So there may be some of that coming in. Thirdly, it must be exposed to the appropriate market. And that happens, the Stern case is a beautiful example of that, where it was a little hobby farm and they listed it in the local market as rural property, and the court said, you didn't reach the appropriate market. It should have been advertised in Toronto as a hobby farm. It would have attracted the appropriate people who are interested in that kind of property, and held the mortgagee liable for not advertising it properly. And then lastly, it must be exposed to the market for a reasonable period of time. Now that means that, and the enemy of the mortgagee in virtually all these cases is haste. It's the anxiety to, and I think the days of dumping properties or so-called liquidating it and getting on with it are over. I think you've got to hold back and restrain from accepting the first offer that comes along. This manufacturer's life case is one that just was recently decided, is a nice example of that. The property was appraised for $250,000. It was listed for $250,000, and they were criticized for that. It should have been listed for a little bit more than the appraised value. And it was sold for $200,000. Okay? $250,000, $250,000, and $200,000 sale. The court listens to the various appraisals and says the true value is $275,000, and awards damages against the mortgagee for $75,000. And what happened there is he didn't paint the thing, didn't fix up a little plaza, and accepts an offer 25 days after listing. It was the first offer that came along. So there you have it. Am I done? I'm done. May I throw one more point in? Because it's something you're going to run into all the time, and I think it's important for practice. And that is, when you do get a sale, what about these clauses in the offer to purchase that say it's subject to redemption and subject to the mortgagee redeeming? We say this sale is in accordance with power of sale and those kind of clauses. That's one thing that has not been standardized and has not been understood, and I will tell you that the mortgagor's right to pay up the mortgage or redeem ends on a sale being entered into by the mortgagee. Once you sign an offer, it's a binding offer, the mortgagor's right to redeem is gone. Now, if you put in the clause, an offer to purchase, it's subject to redemption by the mortgagor, he has no right of redemption. So that clause is worthless. And in fact, the leading case says, the clause said, acceptance by the vendor hereof shall be subject to the rights, if any, of the owner of the property of redemption. And the mortgagee sells, and the mortgagor tries to redeem, and they say, game over. So if that clause has to be very carefully drawn if you intend to give rights to the mortgagor to redeem up to closing or within a week prior to closing. Or if you want to give extended rights of redemption of the mortgagor, make it clear. The last case decided on this had a clause that said, this agreement is conditional upon the mortgage not being redeemed by any parties having an interest in the property up to the date of closing. And that was held sufficient to permit the mortgagor to redeem. And the mortgagee would like to have the mortgagor redeem. After all, it relieves them of the accountability of the sale. Why not get paid off before you have to close the sale? Thank you. Sorry, Frank.
Thank you, Martin. I'd like to make one quick comment about the standard of care that he referred to. The principles that he's mentioned are fantastic principles. It's an area that's going to mushroom in Ontario, and it applies or could apply to landlords, as a question put earlier to Steve Posen, as to the standard of care of a landlord in exercising a distress right. Of course, it can apply to other types of secured creditors, not necessarily a mortgagee, but it could apply to a bank with respect to debentures, Section 178 security, and I think it could even extend to trustees in bankruptcies and liquidators. And as some of you know, the Bankruptcy Act does provide for sales, and it spells out the conditions of it, but it doesn't provide for the standard of care. And that's an area where, if you're representing unsecured creditors or execution creditors, you may have some reason to attack a trustee, liquidator, bank, mortgagee, or whatever for failing to meet that higher standard of care. Our next speaker is Joel Richler. Joel is a partner of Blake Castles and Graydon in Toronto. Fortunately, Joel has come to us from Quebec, and now a member of Ontario Bar. He has a number of scholarships through his academic career prior to becoming a solicitor in this province. He has also been exposed to teaching. He's been an instructor and a lecturer in the bar admission course on creditors and debtors' rights. And he's been involved in a number of civil litigation matters involving debtor-creditor, and especially construction liens. He's an author in his own right and has written many articles in this area as well as other areas. Joel, please give us some insight on the construction liens in Ontario.
I'm not sure I understand the reference to Quebec in that introduction.
Their loss, our gain.
Well, I've been asked to give you a brief overview of some of the aspects of the Construction Lien Act in some 40 minutes. I'm not sure that's possible. It's certainly a daunting task. Many lawyers that I know like to shy away from the Construction Lien Act because it's viewed as overly technical and onerous. I don't personally view it as being more technical or more onerous in other areas that we've heard about today. It is true, however, to say that the Act is very technical and that the time limitations contained in the statute are interpreted and applied very strictly. For those reasons, it's important when acting for lien claimants in particular that you act quickly and that you act accurately. Lien statute, it's not a new remedy. It was introduced into this province over 100 years ago. The lien statute has been amended and some might say reformed recently in 1983. The intent of that, as I understood it at the time, was to simplify the remedy, make it more understandable to those people that it was intended to benefit, particularly people in the construction industry and the trades. My own view of the statute is that it is not any more simple to read than the previous statute. If anything, it may be more technical, more rules to understand, and I don't believe that it provides an easily understood remedy to people in the construction industry. I certainly do not personally believe that it is an expeditious remedy, any more expeditious than ordinary litigation might otherwise be were it not for the security that the Lien Act creates. I'd like to focus first on the quantum issue. In other words, what the lien right gives to a lien claimant and what the exposure is to an owner or general contractor, a payer on a construction project. And I start here because in my experience, I find, before I do that, I should tell you that my own practice tends to involve owners and general contractors, so that if you detect any bias against lien claimants, at least you know where I'm coming from. But in any event, I find that my clients tend to not understand the degree to which the liens give them protection, or speaking from the owner's perspective, they tend not to appreciate the degree to which the statute creates liability. And I think it's important to start at that point for that reason. We start with the concept of holdback. And the concept of holdback really operates in the following way. Where somebody is obliged to make a payment on a construction contract, and it can be a general contract or a subcontract, the Act requires that a certain percentage of the value of the work performed under that contract be retained by the party making payment, and it's 10%, so that only 90% of the value of work performed may be paid for from time to time. It's that 10% withheld amount which serves as the security for the lien claimants. That is the fund that they look to in most cases. And that is described in the statute as the basic holdback. And it's in the majority of cases, that's the holdback we're talking about. The holdback is not required to be actually set aside in a separate account. It's more of a notional concept. It really is a measure of the minimum statutory obligation that payers have under the statute to secure the claims of the parties who actually perform the work on a project. And that holdback has to be retained again by the owner, and it has to be retained by the general contractor, and so on and so forth down the construction pyramid of subcontracts. Apart from that, the Act also requires payers under a contract to withhold the amounts of liens that may be registered at the time the payments are being made, if the payer has written notice of that lien. So that if, for example, you have a contract where there is a $10,000 holdback and the owner or general contractor is required to make payment, if a subcontractor or supplier of materials registers a lien on the lands which are the subject of the improvement, and if that lien claimant provides written notice of that claim for lien to the party that is making the payment, be it owner or general contractor, then that payer has to retain, in addition to the 10% holdback, it has to retain the value of the claim, of the amount claimed in the claim for lien, so that that too forms part of the security of the lien claimant. That only operates if the lien claimant has provided written notice of the claim for lien to the party making the payment. To get ahead of myself a little bit, it becomes therefore very important when you're registering a lien on behalf of a lien claimant to deliver immediate written notice of that claim for lien to all of the superior parties in the construction pyramid, the owner, the general contractor, and subcontractors. And that can be done before registration of the claim for lien. It should be done immediately. That ensures that the hand of the paymaster is stopped, that the monies are set aside or segregated, be it actually or notionally, for the lien claimant, and they serve as a security. If written notice is not sent, then the owner's statutory liability is limited to the 10%, and as is the general contractors. And that's an important concept to appreciate, I think. The 10% holdback will always be there. If the owner fails to maintain the holdback, then lien claimants can sue the owners for that failure, and they can look to the owner for payment of any deficiencies in the holdback. Similarly, if there are mortgages on title and if there are special mortgage priority rules, generally speaking, if there is a deficiency in the holdback, if a mortgage, for example, has been given to finance the building of the improvement, then that mortgagee will lose priority to the extent of the deficiency. So generally speaking, the security of the lien claim will be the 10% holdback from time to time. Insofar as how this operates, liens arise as soon as lienable work starts. If a subcontractor goes onto a construction site and starts his work, he has a right of lien. And the right of lien is equal to the price of his supply of services or materials from time to time on the project. A lien will expire under the Act if it's not preserved within a certain period of time. And by preservation, well, preservation is the statutory language for registration of a claim for a lien, or in some cases, delivery of a written notice of claim. The point, though, is that the lien expires if that's not done in time. Preserved liens, that is, registered claims for lien, also expire if they are not perfected within a certain period of time. And by perfection, the Act means an action is started in the Supreme Court of Ontario to prove the lien amount, to prove the entitlement to a lien, and to obtain judgment for the value of that lien. Even if you have a perfected lien, that is, even if you've started a lien action in the Supreme Court of Ontario, that lien will expire under the Act if you do not have the action set down for trial, or if you don't obtain an appointment for trial of the action within a certain period of time again. In that case, we're talking 2 years. Lien actions must be set down for trial, or appointments must be obtained for trial within 2 years after the action starts. That is a time period which is often forgotten, perhaps because it is a time period which was introduced only in 1983. It didn't exist in the same way under the old Act. In each of those cases, if you fail to preserve, if you fail to perfect, if you fail to set the action down for trial, the lien expiry will be automatic. The courts do not have jurisdiction or discretion to waive that defect. As I've said, the lien arises when the work starts, and the lien is equal to the price of the work or services performed. And by price, we usually mean, in the vast majority of cases, the invoice amount on a contract, the amount which is due and owing or invoiced by the payer to the payee. You cannot lien for damages for breach of contract. You cannot lien for delay claims, extra costs that you incur by reason of delay. And you cannot lien for interest. That's specifically prohibited by the Act. So what we're really talking about here is a remedy which is designed to effect payment for services rendered in a price sense. Because of that, lien actions often get complicated by other issues, because very often where there is a problem in payment on a construction site, there will also be problems in terms of one party alleging that another has breached a contract, or a subcontractor will say that he suffered damages because he hasn't been allowed access to the site, and so on and so forth. Those may lead to claims which are made by way of action, but they are not properly lienable per se. The actions tend to get complicated, though, because of those things. And that's one reason why it is not true, in my view, to say that the lien action is a particularly expeditious remedy, because more often than not, there are complicating factors. Preservation of the lien is accomplished by registering a document known as the claim for lien, or in some cases by delivering that document. And in the material, in the larger material that Mr. Bennett has prepared, at pages 334 and 335, there's a handy fact sheet, I suppose Frank would call it, entitled Information Required to File Claim for Lien. And that is information which, in most cases, must be obtained in order to preserve your client's lien right, if you're acting for a lien claimant. And most of those elements are required by the statute to be set out in a rather simple form called the claim for lien. It's a statutory form. The problem with all of this, again, is that these things have to be done on time. And while I don't act for that many lien claimants, it's my experience that lien claimants tend to walk in your door on the 42nd, 43rd, or 44th day after, or on the first, second, or third day before their lien rights expire, they have a problem. The problem is they're not being paid, or they envisage that they won't be paid, and they want to secure their claims. And more often than not, particularly with inexperienced lien claimant clients, they will not have the required information, and you will end up scrambling. If you're acting for a lien claimant, you'll end up scrambling to obtain as much of this information as possible at the last moment. Certainly, looking at that sheet, the lien claimant's name should be filled out properly on the claim form. The party with whom that lien claimant contracts should be filled out as properly as possible. Lien claimants will usually know who they're dealing with, but if there's time, proper corporate searches should be done. The owner of property is listed as item number 3. Owner is not really used in the Lien Act as many would interpret the word. Lien claimants have liens against the interests that people have in property, the interest that the owner has in property. That's not the same thing as saying that you have a lien against the owner's interest in the property. Owner does not mean registered owner. Owner is defined in the Lien Act as somebody who has an interest in property, leasehold interest, for example, but it also has to be somebody who's had some degree of relationship with the contract that leads to the making of the filing of the lien. There has to be some relationship with the improvement and some benefit obtained by the owner, so that the concept of ownership is broader under the Act than simply saying registered owner, and in some cases the registered owners will not be owners within the meaning of the Lien Act. Landlords, for example. The name of the general contractor should be obtained, even if you're acting for somebody who supplies services to a subcontractor, because the general contractor will, in many cases, have some degree of relationship to the claim being made. You'll want to contact the general contractor in order to determine why there are problems in payment. In many cases, the general contractor will be the party that vacates the lien off title by posting security, and you, acting for a lien claimant, will want to know who you'll be dealing with in that context. The time within the work or materials were supplied is very important. You have a right to preserve a lien, generally speaking, within 45 days of your last supply of services or materials. It could be shorter. It could be a shorter period of time if the project has been substantially performed and if a certificate to that effect has been published in the Commercial Daily News. But it is certainly patently improper to register a claim for lien more than 45 days after your client's last supply of services or materials. That information has to be obtained from the client, and it's got to be accurate. And it's got to be accurate because the claim for lien will be supported by affidavit. And if there are documents around, or if there is evidence that shows that the lien claimant did not attend the site on the indicated date or as late as the indicated date, then the affiant can be cross-examined, evidence can be adduced in that way, a motion can be brought to vacate the lien, and the client will have lost its security. So that has to be obtained, and it has to be confirmed, and that allows you as solicitor for the lien claimant to schedule when you have to accomplish the preservation of the lien. Number 7, particulars of account. Obtaining of invoices is something that should be done, again, because it helps support what you're doing. It's important to note that contrary to prior law, you can only lien for amounts that are owed as at the time you're claiming your claim for lien. So it's important to know how much your client is owed, not how much your client envisages that it might be owed in the future. It is important to know where the lienable work was done. While you can make mistakes that are excused on the claim for lien form, you cannot make a mistake dealing with the legal description. That has to be accurate. You have to register the claim for lien in the right land registry office or land titles office. And I can tell you from personal experience that it pays to check. I was acting for an owner in one situation where the property had been transferred from from land registry to land titles 10 years before the lien was placed. The lien claimant registered nevertheless in the land registry office, and we successfully had the lien. Well, there was no lien. We successfully had the matter disposed of on that basis. You'll want to know if work has been done in a leasehold context or a freehold context. There are provisions in the Act for serving notice on landlords by lien claimants in order to have the landlords responsible for claims for lien. landlords can disclaim that. But even if those notices aren't sent, in certain situations, landlords can be held to be owners under the Act. A typical example, which is still an open question, being shopping center landlords, where work is done in a store premises and where arguably the work is done for the benefit of the owner, notwithstanding that it's the tenant that's commissioning the work. It can be argued that the landlord will be the owner, and you will want to know those facts as soon as possible when preparing the claim for lien and ultimately the statement of claim. Again, it's important to confirm the information from the client by doing a sub-search, and you'll want to have the identity of the owner confirmed, the mortgages, holders of liens, etc. You'll want to check whether or not the project on which the lien claimant has been working has been certified to be substantially performed, because if that has taken place, even though the lien claimant has been there within 45 days immediately prior, then his lien rights will have expired. The key number to remember is 45. The information to be obtained has to be accurate, and it has to be and the claim for lien has to be preserved within 45 days, failing which it is gone forever. Perfection is the next step, and in most cases, perfection is accomplished by suing, as I said earlier, and that is in the Supreme Court of Ontario. And the action has to be commenced in the county or district within which the land is situated. You cannot do work in Barrie and then start a lien action in Toronto. And it does happen that those actions are started. They are not properly perfected liens in those cases. In addition to starting the action, you have to register a certificate of action, which is a short statutory form. That certificate of action is registered in the pertinent land registry office or land titles office, and it serves as evidence on title that the liens have been perfected. It is also possible under the Act to perfect your liens by sheltering under existing actions. In other words, if somebody has started an action related to the same improvement at the time you preserve your lien, you can perfect your lien simply by following along in that action. That is generally not a good idea, in my view. In my view, it's worth the cost of preparing a statement of claim. You'll have to do that anyway. And it's worth the small cost of registering a certificate of action to ensure that your lien is properly preserved. Once perfection takes place, then generally speaking, liens are proved in court in much the same way as in any other civil proceeding. There are some peculiarities, however, major one being that lien actions are consolidated actions in the sense that where you have an improvement and you have several liens that are perfected against that improvement, all of those liens will be tried together in one forum at one court before the same judge. There are restricted rights on the degree to which you can bring third parties into the action, the degree to which you can cross-claim against parties who aren't already in the action. To that extent, those procedural rules that are found in the Act supersede the rules of civil procedure, so one should have regard to those. One example that comes to mind is that under the rules of civil procedure, a defendant can cross-claim against a party not already a party to the action, a counterclaim, I should say. That cannot be done under the Lien Act. So those have to be regarded. A time period that has to be considered is service. Under the Act, statements of claim must be served within, I can't remember if it's 60 days or 6 months. I think it's 60 days of issuance. That time period can be extended, but it's something that should be kept in mind. Efforts should be made to serve the statement of claim as quickly as possible. Lien actions are generally heard before a local judge in the county or district within which the land is situated. In Toronto, unless a reference is ordered, they're heard by a Supreme Court judge. In the vast majority of cases, lien actions, because they involve issues of accounting, are referred to the masters, Master Sishy or Master Sonder in particular, and that is accomplished by a motion in weekly court, usually ex parte, usually without objection, in which the moving party obtains a judgment directing a reference to a master for determining liability. Once you are at that stage of the proceedings, you are required, as I said before, to obtain a trial date or an appointment for trial within 2 years. If you're in Toronto, where I suspect most lien actions are heard, that is accomplished by an ex parte motion to the master, certifying to him that the pleadings have been closed, that all that has been done, all that required to be done has been done by that stage of the proceedings. The master will set a so-called trial date, and you will be then required to deliver a notice of trial giving at least 10 days notice of that date to various parties, including all lien claimants, all parties against whom liens are claimed, execution creditors, and the like. The master will have to be satisfied at the trial date that all of the parties that require to be served have in fact been served. As an alternative to proceeding immediately to a trial date, the Act contains a procedure for the convening of so-called settlement meetings. Very often settlement meetings are useful. They help to resolve some issues that may exist between lien claimants. They allow the lien claimants to get together to have the claims vetted. Usually, if there are a large number of claimants, small committees will be struck to have the claims reviewed to determine quantum issues, and that can simplify the matter. It is my experience that significant issues do not get resolved at settlement meetings, and they usually are just a form of pretrial conference without a judge being present, and you then proceed from that point to trial. Settlement meetings are not mandatory under the Act, although in some counties, when you obtain a trial date, in fact, what you are obtaining is a settlement meeting date. In terms of, say I'm running short of time, Frank asked me to devote some attention to the extraordinary remedy under the Act of having a trustee or receiver appointed. And that is under the section of the Act entitled Extraordinary Remedy. I don't know if the naming of the section was intentional or not, but in fact, the remedy is extraordinary in the sense that it's not often followed. And it can be useful. And I can think of one example which I'll put forward as perhaps a bit of an archetype. You have a large project, a large construction project, in this case involving the construction of single-family dwellings by a developer, which was also acting as its own contractor through a subsidiary. The developer slash owner slash general contractor went bankrupt. You had several unpaid trades, numbering 20 to 30, who register liens not unexpectedly over all of the property. At the same time, you have several very unhappy families who expected to have homes to move into. Construction has stopped. It's necessary to complete the homes, deal with the lien claimants, deal with the owners in as expeditious a way as possible. And the way that was done in this particular case was that a receiver or trustee under Section 70 of the Act was appointed. And that creature, and they tend to be, in my experience, limited experience that I do have, is that they tend to be licensed trustees in bankruptcies who have a particular experience or expertise in the construction area. They have the power, much like court-appointed receivers, to act subject to court supervision and direction, to engage in the protection of the job site, protection from vandalism, protection from the environment. They have the power to negotiate contracts for the completion of the project. They have the power to mortgage the properties to finance that completion, in which case the new mortgage would have priority over the liens. The receiver would have the power to sell or lease the property after completion. The trustee or receiver would have the power to negotiate with the lien claimants in order to quantify the amounts owing to those lien claimants, all again subject to court supervision and direction. The lien claimants will have notice of all of the steps being taken by the receiver, either through a committee of lien claimants or through the services of notices of motion every time an appointment is made before a judge to have matters approved. The liens will charge the money that the trustee receives as a result of selling the property. The trustee or receiver will have priority over that money to the extent of reasonable business expenses and fees incurred in his capacity as lien claimant's trustee. The dispositions of the property can be subject to encumbrances, and in essence, it's a statutory form of court-appointed receiver and manager, which is of particular use to lien claimants and to others having interest in the property in situations where you have a large project which, for one reason or another, has gone down. I've run out of time. Any questions?
Is this essentially the same principle as the old Mechanics Lien Act under, I believe it was part 4 from the first year? Is there any material difference or variance in the procedure?
That was under Section 38, as I recall. I don't believe there's any substantial difference. If anything, the language of the new act gives a little bit more clarity. There are minor differences in the way the sections are drafted, but my recollection is there are no substantive differences. I know I've glossed over a lot, but sorry.
How would that procedure rank vis-a-vis a bank loan procedure and a debenture security that's fixed priority on the property? I think it's typically the ability to borrow further money to carry the project on.
Well, that the fixed security that's registered on the property, everything being equal, would have priority. Priority relative to a mortgage acquired to finance completion would be the subject of negotiation between, if that were appropriate, and there certainly could be subordination of interest. But generally speaking, the bank security would rank first, unless that security would, under the normal provisions of the Lien Act, lose certain priority as a result of deficiencies in holdback or things of that nature. Thank you.
Are there any other questions? Thank you very much, Joel. We're going to break now for lunch. We're running about 15 minutes behind. So let us come back by 1:30 sharp, please. Thank you. Under in. Our next speaker is Martin Black from Beamont and Green in Ottawa. He is going to talk about PPSA, the rights and remedies, and what happens on default. And he's got a show for you of great slides and a couple of jokes in between. Marty?
I'll let you pin me.
You're pinned.
Or pinner. Does this mean we're engaged?
Michael.
Yeah. I think we're going to dim the lights, and hopefully by the time I'm finished speaking, you're not going to still be in the dark. Just tell me if you can see this from the back. Can you read that? A little higher, maybe? Can anybody read that? It says, I can read it, but I don't understand it. It seems to be a primitive form of the PPSA. And the reason I start with that is to remind everyone here that the PPSA is kind of a continuum of a series of older pieces of legislation to which we still refer from time to time in terms of similar terminology. It replaced in 1976 the Bills of Sale and Chattel Mortgages Act, the Conditional Sales Act, the Assignment of Book Debts Act, and all of that was to provide uniformity because what we had before was an administrative nightmare trying to have all of these acts jive with one another and where there was apparent contradiction. Therefore, it is still relevant to refer to some of the old jurisprudence under some of the old statutes. And similarly, I want to say in passing that it is relevant today to refer to American law because our PPSA is based on the United States Uniform Commercial Code, as are other provincial statutes here in Canada, notably Saskatchewan and Manitoba, and I understand British Columbia has just enacted their own PPSA. So we're not restricted to jurisprudence in the Ontario Forum. There have been several amendments over the past 12 years, and we are presently awaiting a totally new, revised Personal Property Security Act, something that's been on the books or at least been under discussion at all levels for the last 4 or 5 years. I spoke with the PPSA legal department yesterday, and they would only tell me that they expect the first reading of the new revised act to be later this month. They are not releasing texts of the revised act. It's strictly confidential, and she wouldn't tell me what was included in the draft legislation. Although I'll give you some hints based on some discussion papers later. This is kind of the feeling that most of us has had over the last number of years in dealing with the PPSA. you want to say, as this fellow in the picture, I've got it, we'll get the legislation amended. That seems to be the only way to deal with an otherwise very difficult piece of legislation, very poorly worded, and a piece of legislation, too, that I must say is very substantive in terms of the regulations passed under the Act. So again, for those of you conducting research in terms of the PPSA, I refer you to the regulations because they're quite substantive, as we'll see shortly. The purpose of the Act really is to establish rules by which charges, or as the Act calls them, security interests in personal property, may be created, and for determining the priority positions of competing security interests and of other third parties, and then finally to determine the rights and obligations and remedies of both the debtor and the secured party. The Personal Property Security Act itself permits full flexibility in the contracting by the parties as they see fit. They do not have any guidelines or restrictions as to the types of terms that you can put into a security agreement, and therefore every security agreement is very different. Every bank form is different. A security agreement which is closest to a chattel mortgage contains language that's similar to a chattel mortgage. We have security agreements that more closely resemble conditional sales contracts. And there is this full flexibility by the parties to contract as they see fit. Section 9 specifically provides that a security agreement is effective according to its terms between the parties to the agreement. So we don't talk, when we're talking in the PPSA, we don't talk in terms of invalid or void agreements, other than, I suppose, when you're talking in terms of basic contract law. The contract, the security agreement, stands and falls in accordance with basic contract law. The prime function of the PPSA, however, is to deal with priorities and rights and remedies of the parties. And in the context of priorities, I hope that this chart kind of demonstrates what we're talking about here. I hope you can read that from the back, but basically what I'm trying to demonstrate here is that you have in the middle of all of this the personal property, or what the Act refers to as collateral. And you have the competing interests, the varied competing interests of the various parties, including the debtor, who is usually the owner or has some rights in the collateral. And then you might have a chattel mortgagee, maybe a bank. You might have a conditional sales vendor, a consignor of those goods, a lessor of those goods, a landlord of premises on which goods are found and may be subject to distraint, the landlord's right to distraint. We all know about lien claimants, both under the old mechanics lien and under the construction lien. The rights of the crown vis-a-vis the personal property owned by the debtor. The rights of an execution creditor, a creditor having gone through the judicial system and having a judgment in hand and an execution on which to realize. The rights, of course, of a bankruptcy trustee, and that's probably the area in which there's the most jurisprudence. That is the competition between a bankruptcy trustee and some of these other parties, notably a chattel mortgagee or a conditional sales vendor. That's where you find most of the jurisprudence under the PPSA. And then finally, the rights of a purchaser of the collateral, perhaps from the debtor or from someone else where a security interest has previously been provided and taken in that collateral. I'm going to come back to that chart in a minute to fill in some of the blanks there. This is an excerpt from the Personal Property Registration Guide, and it paraphrases Section 2 of the Act, and it outlines that the Personal Property Security Act applies to every transaction without regard to its form and without regard to the person who has title to the collateral that in substance creates a security interest, including what we used to call and what many of you still refer to as a chattel mortgage, a conditional sale, equipment trust, floating charge, etc., and an assignment, lease, or consignment intended as security. The Act governs all of those relationships, and it also governs all assignments of book debts, whether or not they're intended as security. Now, the one area that the guide adds that is not included within the Act are mortgages, charges, and assignments, the registration of which is provided for in the Corporation Securities Registration Act. And I can tell you that one of the main features of the new Act, the new PPSA, is to repeal the CSRA, because as I'll discuss shortly, there is some conflict between the PPSA and the CSRA. So they do intend to repeal the CSRA. Now, because the PPSA applies without regard to form to a wide variety of transactions, the list of definitions contained in the PPSA are quite lengthy, and they again provide uniformity. And all the definitions are found in Section 1 of the Act, and you have it somewhere or other in your materials. I just want to highlight the basic terminology that we invariably refer to, and that is the security agreement, which is defined in Section 1X, and that's the document itself, the source document. It includes, as I said, a chattel mortgage, a conditional sales contract, typically are the two types of security agreements that we deal with. They can be a specific security agreement, which charges a particular asset. It can be, for example, a chattel mortgage on your car is a type of security agreement. It can be a general security agreement, which creates a security interest in all of the debtor's assets. Security interest is defined in Section 1Y, and it actually contains an expanded version of what you see before you. It's an interest in collateral that secures payment or performance of an obligation and includes an interest arising from an assignment of book debts. Collateral, of course, is the property that is subject to the security interest. Interestingly, the term personal property is nowhere defined in the Act, but by deductive logic and by inclusion, it includes goods and consumer goods. The goods, of course, being largely chattel's personal property. Consumer goods, and this is an interesting definition, one that we don't always regard. It's goods that are used or acquired for use primarily for personal, family, or household purposes. Query the categorization of a company automobile, which is purchased by the company, but is really used primarily for the benefit of the company's president and or his wife or kids. And very often you'll find that the banks will only classify the security as equipment. A query whether they should also classify it as consumer goods and whether they would be prejudiced if they failed to do so. Inventory is covered by the Act and is defined by the Act, and so is equipment. And there are a long list of definitions. And I emphasize this because it's important that you're consistent with the type of terminology that you use. It's terminology that isn't altogether familiar to the bankers. We're constantly updating them in terms of their terminology, and there's nothing wrong in using the old forms, but as this lawyer is saying to his client, layman's terms, listen, I didn't spend 5 years in law school to put things in layman's terms. So I think it creates a little bit of legalese there that people, lawyers especially, like to use. Now, there are a number of transactions or relationships that are not governed by the PPSA, and I want to touch on them. And this is when I want to refer back to the chart. And it's relevant because what the PPSA does, as I said, is encode, really codify a list of rules that one must proceed by in order to establish priorities and in terms of their rights of realization, their remedies. Firstly, a true consignment. Okay, if you have a situation where a consignor of goods delivers goods to a consignee under a true consignment or an absolute consignment, that is excluded from the Act, and that's by virtue of Section 2. That as distinct from, or as distinguished from, a consignment that's really intended as security. And you get into, and I won't bore you with all of the various indicia of whether, as determined by the courts, as to whether a relationship is a true consignment, an absolute consignment, or a consignment, to use the terminology in the Act, a consignment intended as security. You have to look at all of the facts of every case, not just the documentation, but as well extraneous evidence in terms of the roles of the parties. Is the so-called consignor really in the business of consigning goods, or just in order to protect him from a bankruptcy or from another secured party did they choose to describe their relationship as one of consignment, consignor, consignee? Or if you actually look at the relationship as defined by the written agreement, if there is one, or otherwise by the roles of the parties, then is it really not just a financing arrangement whereby the goods are paid for over time? And as I say, there's a long list of factors that are used by the courts to determine that matter. Similarly, we have something which is more common, and most of you have probably encountered this, and that's leases of personal property. If a lease is a true lease, if it's one that is not intended as security, then there are similar considerations as the consignment. It is not governed by the Act, and again, that's also by virtue of Section 2. Again, similar considerations apply. The main factor seems to be the factor that's applied by the courts most often is this issue of a terminal payment at the end of a lease term, an option to purchase, whether the lessee has an option to purchase, say, the vehicle. Most commonly it's a car lease. And if so, at what price? Is it market value? Is it nominal? Does it reflect the state of the car at the end of the term? If it's nominal, the courts have held that all other things being equal, that's probably a finance lease. It's probably a lease intended as security. Now, maybe I should tie in the relevancy to all of this. If it's intended as security, either consignment or an assignment or a lease intended as security, then it's governed by the Act, and then as we'll see shortly, the rules in terms of perfection and ultimate protection of that asset as against a bankruptcy trustee, as against another bank, come into play. So therefore, if you feel as a trust company or as a car dealer that you've got a true lease, and therefore you choose not to register a financing statement in order to perfect your interest in the lease, because after all, you're the owner, and all you're doing is leasing the vehicle, and if you're wrong in that decision or in that characterization, then as determined by these various factors and as ultimately determined by a court, perhaps in the context of a bankruptcy or a challenge by another secured party, and you failed to register your financing statement, then you're going to be subordinate. Even though the lease is written as if you own it, and it's a true lease, if because of all these other factors, the option price is nominal, etc., if you're found to have created a security interest because it's a lease intended as security, you're subordinate then to the interests of the bankruptcy and trustee, for example. And that's why it becomes very relevant, and that's why lenders and especially car lessors should not just automatically assume because they call it a lease that they're governed by the terms of the lease and they can come and repossess their car at any time, bankruptcy or no. Okay. Similarly, the rights of the Crown are excluded from the Act, and that's referred to in Section 22. Just make note if anybody likes taking down section numbers. 22, 1A, little 1. And the Dockstader case, that the Crown is exempt. Now, I understand under the new Act, the Crown is going to be bound by the provisions of the PPSA, although that's one of the confidential matters that they wouldn't disclose. Lien rights. Okay, lien rights are specifically excluded from the application of the PPSA by virtue of Section 3, 1A, and a combination of that and Section 32. Lien claimants such as pursuant to the Bank Act, the Construction Lien Act, the Mechanics Lien Act, and most notably here, pursuant to the Landlord and Tenant Act, whereas you know a landlord has a right of distraint, which is a lien in law, and by virtue of the Harry Shields case, which is referred to on page 107 of your materials, the landlord has higher rights than a secured creditor in one sense, in the sense that the landlord is outside of the realm of the PPSA. He can go in and effect his distraint pursuant to the Landlord and Tenant Act, and you get into all sorts of weird and wonderful ramifications of that, including a friendly bankruptcy or a secured creditor who otherwise wouldn't be interested in a bankruptcy petitioning or encouraging the debtor to make an assignment into bankruptcy, thereby reversing the priorities, because a trustee in bankruptcy has priority over the landlord. Although the landlord outside of the bankruptcy would have priority over the secured party, in the context of a bankruptcy, The secured party has priority over the bankruptcy trustee, who in turn has priority over the landlord. So that's why secured parties often use the vehicle of a bankruptcy to gain a higher priority. The types of assignments and charges provided for under the Corporation Securities Registration Act are in a sense, or there's a provision in Section 3 that those documents are not governed by the PPSA. On the other hand, by virtue of a line of cases, notably the Court of Appeal in Euroclean, which is referred to on page 108 of your materials, the conclusion is this, and I'll just skip to the conclusion. Out of an abundance of caution, until the new act is enacted and until the CSRA is repealed, when you want to take a debenture or a floating charge or a general security agreement from a corporation, of course, when we're talking with the Corporation Securities Registration Act, we're only dealing with corporations, corporate debtors. The best way to affect your highest priority is to take a debenture and register that pursuant to the CSRA with the ministry here in Toronto, and have the debtor execute a general security agreement and register a financing statement pursuant to that agreement under the PPSA. And the reason for that is because the case is held that if you only register under the PPSA, then you will be governed, you, the secured party, will be governed by the provisions of the CSRA, of the PPSA, I should say. And that may not give you the best flexibility or the highest priorities. If you register both under the CSRA, the debenture, and the financing statement under the PPSA, you'll have maximum flexibility. And it may be that for certain purposes you'll want to proceed under the CSRA, where the notice provisions, for example, are not spelled out, and where just reasonable notice has to be given in terms of a sale of the collateral, as opposed to the PPSA where 15 days notice has to be given. So there are some very relevant circumstances under which you'll want to proceed by double documentation, dual registration. But this, as I say, will be simplified by the new act whenever it's enacted. Interests in real property are also exempt under the PPSA, except where what you're doing with the real property is really a security relationship, and notably where an assignment of leases is taken by a secured party as security. It's not an assignment of leases pursuant to an outright sale of the property. If there is that assignment of lease, then I don't think it's necessary to register a financing statement if it's an outright sale by the landlord and he's selling the leases along with the sale of the property. Similarly, if it's an outright sale of a charge, of a mortgage, if a chargee decides to broker his or sell his mortgage, then that doesn't have to be perfected or registered pursuant to the PPSA. But if a charge, a mortgagee's position under a mortgage, is pledged to a bank, then that has to be registered pursuant to the PPSA because that's a security arrangement. Now, the bankruptcy trustee position is the most interesting one, and it has priority over an unperfected security interest. The bankruptcy trustee has priority over an unperfected security interest in certain circumstances by virtue of Section 22(1)(a)(3) and 22(2). And there are certain criteria that the trustee has the onus of proving, and that is that there was at least one unsecured creditor that was unaware of the security interest. But suffice it to say, for present purposes, that if a secured party is claiming to have a security interest in a property that's owned by a bankrupt, then it had better be perfected. Okay, the secured party had better have a perfected security interest, or it may find itself subordinate to the interests of the bankruptcy trustee. And finally, up here, the purchaser under Section 30, a purchaser who buys goods from a seller who sells those goods in the ordinary course of business, that purchaser takes title free and clear of any security interest that was created by that seller. Okay, so it's protection from for a purchaser, a consumer buying inventory in the ordinary course of business. It's not perfect protection, however, because of the rather convoluted wording of Section 30. When we're talking in terms of security interests, there are basically two elements that we're concerned with: the creation of the security interest and the perfection of the security interest. When we talk in terms of the creation of the security interest, we talk in terms of attachment of that security interest to the collateral. And I refer you to Section 12, which determines when a security interest has attached or has been created, has attached to the collateral. It's when the parties intend it to attach, when value is given by the secured party to the debtor, and when the debtor has rights in the collateral. And usually that's pretty well contemporaneous with the signing of the security agreement and the giving of the loan in exchange for the security agreement. That's when the security interest attaches, because that's what the security agreement usually provides. I must tell you as well, though, that the Act does recognize after acquired property, so that in your security agreement you can provide for a charge on assets which the debtor doesn't yet own. So all inventory, equipment, etc., now or hereafter acquired, now owned or hereafter acquired by the debtor. And that's legitimate, and that's recognized by the PPSA. Now, in order to protect your security interest to the highest, from all of these other third parties out there, then you must perfect your security interest, to use the terminology of the Act. And basically, there's two ways to perfect the security interest. The most common, of course, is the registration of the financing statement. That's the easiest. It's pursuant to Sections 25 and 47 of the Act, and I'll get into the requirements, the very picayune requirements of the Act when it comes to registration of the financing statement. But the other lesser-known manner of perfecting a security interest is by possession of the collateral, which usually isn't, when you give a loan on a car, for example, obviously the bank's not going to keep the car, defeats the purpose of the loan. But it does apply, for example, to share pledges or other such types of actual pledging of security. But as a result of certain case law, including the Sharon case, it has now been held that repossession of the collateral after default constitutes perfection. The reason I mention this, it's very relevant, because if you or your client fears that you're not properly perfected by registration, either you forgot to register, you had a defective financing statement, as I will discuss, or you thought you didn't have to register because you assumed that you were a true lease, and then your lawyer then tells you, or you tell the client, that it's a lease really intended as security. Before the bankruptcy trustee is interposed between you and the asset, go down and grab that asset, grab that car, because repossession constitutes perfection of the security interest. Needless to say, if the bankruptcy has already taken place, then you, as a secured party, cannot merely repossess the collateral. Now, there is a special type of security interest which has a super priority position recognized by the PPSA, and that's called a purchase money security interest. You're probably familiar with that term. We refer to it as a PMSI, by the abbreviation Purchase Money Security Interest. The definition is found on page 116. Basically, that's where a security interest is taken or reserved by the seller of the collateral. In other words, a conditional sales contract, where the vendor sells but reserves title. Doesn't matter whether he reserves title or not. The fact is he reserves onto himself or takes a security interest. That's a purchase money security interest. Or where a person gives value to a debtor in order for that debtor to acquire the collateral, and the debtor actually uses that value, usually money, to acquire that collateral. So if you go to a bank and you make a loan for the purchase of a car, and you actually apply those monies towards the purchase of that car, then that bank, and then you give a chattel mortgage, say, or a security agreement to the bank, then that bank has a super priority called a purchase money security interest. Now, I'll get into priorities shortly, but in terms of the issue of perfection, I think because I'm running short of time, this is usually a 2-hour lecture at the bar admissions course, I want to just briefly go through what is probably the most damaging part of the PPSA, and in particular, it's found the problems arise not by virtue of the Act itself, but as I said before, by virtue of the regulations, which are very detailed and very substantive, as has been held by the courts. Keep in mind that the whole PPSA system, the Personal Property Security Registration System, is a centralized computer system here in Toronto for all of Ontario. If you know computers, you know the garbage in is garbage out. And so the system requires precision. You must be absolutely accurate and exact with the information that you provide on your financing statement, which then in turn gets entered into the computers. So the courts have easily held that a defect in certain material parts of the financing statement may well destroy your perfection, your registration. Doesn't destroy your security interest. Remember what I said before, we don't talk in terms of void or invalid. We're talking in terms of priority now. So by improperly completing this statement, you may well have screwed up your priority. You may have lost your priority. This is the part of the lecture I refer to as the name game, or subtitled, "A rose is a rose is a rose is a rose," and I caution you, that's not the case. Let me give you an example. Richard John Rose, who's carrying on business as Rose's Flower Shop. Richard is known to all of his friends and his business acquaintances, and all of his life has been known as Dick. And he comes to you, the banker, and says, "Hi, I'm Dick Rose. I want to make a loan." Banker says, "Fine, sign here. Here's a security agreement for you to sign," and registers here where it says, I'm blinded here. Here, under individual debtor, first name, Dick. Under initial, well, I didn't ask the initial, and surely it's not relevant. Leaves that blank and puts in Rose as the last name. I'm here to tell you, and you've probably heard this before, that that is a fatal defect. It is non-curable defect under most circumstances. That is where the information given on the source document, the security agreement itself, is merely transcribed onto the financing statement, and it was wrong for whatever reason. We don't have to allege fraud here. It doesn't matter that whether he was innocently misstated his name because he's always known himself to be Dick, okay? Or he fraudulently, and that's another area altogether when you get into fraud, or he intentionally misled you, the banker, by saying, "My name's Dick," knowing damn well it's Richard, and that would screw up the system. So the onus is on you, the banker, the secured parties, and you have to tell this to your clients, to take the proper identification when dealing with people, because not only is it important to get the exact given names, to use the terminology in the Act, in order to provide that information. Let me give you another example. If all of his life Richard John Rose went by his middle name, everybody knew him as John Rose, and we have now reported cases on that exact same fact scenario, and you, again, didn't bother to ask for identification, didn't ask for proof, and you simply register very innocently against John Rose. That, too, has been held to be defective. Okay? Your registration is useless. It's not something you can cure, and it's not something that you can amend, by the way. Some lenders are out there frantically filing financing change statements, amending a previous inaccuracy, and there's now a case that holds you can't revive a corpse. If it's fatal, and you can't cure a fatal defect. Okay, now change the facts slightly, and this fellow comes into the bank and he says, I'm Rose's Flower Shop and I need a loan to operate my business. Okay, the first question the banker should ask is, who is Rose's Flower Shop? Is it a sole proprietorship? If it is, then the financing statement must show the name of the individual carrying on business as a sole proprietor under the name of Rose's Flower Shop, must contain the full information, the first given name and the initial of the second given name, and the last name and the birth date, by the way, when dealing with an individual. And you can also optionally show as an additional debtor the firm style, Rose's Flower Shop. It does not suffice, however, only to put Rose's Flower Shop without indicating who the sole proprietor is that's behind Rose's Flower Shop. So you must, in this case, put Richard J. Rose, his birth date, his address, and then you can also add Rose's Flower Shop. That's by virtue, again, of the regulations, Section 14, subsection 3. Now, if Rose's Flower Shop is actually a partnership, then different rules prevail. If the partnership is registered under the Partnerships Registration Act or under the Limited Partnerships Act, then you can register just against the name of the partnership. Okay? If it's not a registered partnership, then you have to register against the name of the partnership and at least one of the names of the partners. Okay? Most people don't know this rather detailed listing of requirements. If you mess it up, if you don't even bother to check to see whether it's a registered partnership or not, and you just put in the firm name and it's not registered, then your statement is defective. Finally, of course, the other typical situation is where you have a company carrying on business, perhaps, as Rose's Flower Shop. It might be Rose's Flower Shop, Inc. It might be 1234 Canada, Inc., carrying on business as Rose's Flower Shop. In the case of a corporation, that's a business debtor, as is a partnership, and should be entered on line 3. The exact corporate name must be entered. And again, I suggest, therefore, you can look at the corporate seal, you can look at the minute, better yet, look at the minute book, look at the articles of incorporation, make sure they haven't been amended, and make sure that you register against the exact corporate name. Now, the other parts of the financing statement are important. For example, the collateral classification, whether it's consumer goods, inventory, equipment, book debts, or other. If you screw that up, there are cases now going both ways as to whether that is a curable defect, whether it is material or an essential part of the financing statement. If the goods or the collateral constitutes consumer goods, then another full section must be completed. And that's why I cautioned you before about the characterization of a company car. The materials are very clear, and of course there's a registration guide put out by the ministry which guides you through these forms. This is a financing change statement for amendment purposes, and that's pretty straightforward. There's nothing too consequential by that form. The next important one that really does come into play is the financing change statement. Same title, but this is a different form. It's a financing change statement for a whole variety of possible purposes, either for renewal. Remind your client when you give him your reporting letter that the financing statement expires 3 years from the date of its registration, or 3 years from the date of its renewal. If you just keep renewing them. By the way, under the new Act, it was proposed, and I'm presuming that they're going to go ahead with something along these lines, variable periods of registration up to 75 years. So you don't have to keep diarying your file every 3 years. But for the lawyers in the crowd, make sure you put the onus on the client to remind him that it's his responsibility to renew in 3 years' time. This form can also be used for discharge purposes, assignment by secured party, or transfer by debtor. And I just caution you, because time is running out, that when a secured party learns of a transfer of the collateral by the debtor, then the secured party has to do something about it. He has to register one of these financing change statements, and if he doesn't within 15 days, then he will have become unperfected. And if in the interim, while he's unperfected, there's a bankruptcy, then again the same rules apply. The bankruptcy trustee is going to take priority. So for you bankruptcy trustees out there, okay, you should inquire as to whether there's been any name changes, by the way, is another thing. Transfers by the debtor, and look to see whether the secured party has taken the appropriate steps within the right period of time to re-perfect against the new owner, or as the case may be. This form is also used for subordinating one security interest in favor of another. These forms, I can tell you, are very tricky because, as any secretary will tell you, you have to type everything in capital letters and you have to get well within the white areas. If you don't, they'll reject it. And this is what our office looks like, where the boss is interviewing a secretary and says, the job calls for some typing and a little filing now and then. Because of all these different forms and all of the requirements, it can really add up. The timing is important. Okay, under normal circumstances, when we're not dealing with a PIMSY, you must register within 30 days following the date of execution of the security agreement. If you're outside of the 30 days, forget about it. Don't even waste your time. It's not as if, oh, well, I was close, or I beat the bankruptcy trustee who wasn't interposed for another 5 days later. If you're beyond the 30-day period, that's it. Okay? And again, it's not something that you can amend later. The only way that you can then correct that situation, if you miss the deadline, is one of two ways that I can think of. Maybe there's another way. You get the party back to re-execute a new agreement and make sure you register within 30 days after that. Or you apply under Section 64 to a district court judge for an order permitting an extension of the time for filing. Okay, I don't have time to go into the effect of defects in these various forms. Suffice it to say, there are curative provisions in the Act, but unless the error in the form was caused by a clerical error, or unless the mistake is in an immaterial or non-essential part of the form, then your defect will be fatal and cannot be cured either after the fact or otherwise. Now, in terms of the listing of priorities, very briefly, I've mentioned to you all of the other, by that chart, the exclusions under the Act. So that governs some of the priorities as well. With respect to perfected security interests, okay, if you have a competition between more than one perfected security interest, the following rules apply. If one is a PIMSY and proper notice was given under the Act in order to protect and properly perfect, because PIMSYs have special perfection rules, and they relate to registration relative to the time of possession of the collateral. If it's a PIMSY and it's properly, and notice was given, in the case of inventory, PIMSYs in inventory, and if you're properly registered, then the PIMSY has priority over a non-PIMSY. If neither one are PIMSYs, then priority goes according to the order of registration. If neither one is a PIMSY and at least one security interest was not perfected by registration, then you go by order of perfection. Okay? If possession by one preceded registration by the other, then the possessor wins, and vice versa. That, in a nutshell, is the PPSA, its purpose, and how it establishes priorities. Chapter 9 of your materials goes through in quite some detail, and quite well, I might add, in specifying the rights and remedies upon default. They're pretty well all contained in Part 5 of the Act, and it's really just a code of what a secured party can do and must do in order to protect the collateral. As part of your supplementary materials, I've prepared a review list, and for trustees especially, and for lawyers who are find themselves acting for trustees or receivers, I find this review list very helpful in order to just tick off the various, and it's just kind of answer the question, yes, no, and then I've referred you to the various sections in the Act for further reference. Thank you very much for your attention.
Are there any questions?
Right, is the priority of a landlord. Can a landlord register on the register's lease on the PPSA?
Marty?
Can a landlord of real property register his lease? For what purpose? If the lease, what I do now is I provide for a security interest in favor of the landlord. I put in a provision, right, not just that the goods on the premises left behind become the goods of the landlord, or the tenant improvements, or whatever the case may be, but I actually put a clause to bolster the landlord's right of distraint, which again can be defeated by a bankruptcy, and I'll put in a clause that the tenant hereby creates a security interest in all the goods now found on the premises or hereafter found on the premises or belonging to whatever the case may be. And then you must perfect, of course.
What about a landlord wanting to register in order to become a secured creditor?
Again, it's a matter of contract. You have to have created, don't forget attachment, you have to have created or attached the security interest to the collateral. The landlord can't just, pull out of thin air a security interest that was never consensually created, been created. I think you should insert it in the lease. It bolsters your rights of distraint. Now, the tenants always ask you to take it out. And maybe build in a subordination in favor of the banker in the ordinary course or something like that. Yes, sir.
What about a PPSA that was registered prior to the security interest being created? How do we get
Where a financing statement is registered before, no, under Section 47, it cannot be registered before the date of execution. It has to be registered after and within 30 days following execution. There's a question at the back? Yeah.
How do you determine the name of an individual who's born outside of Canada?
A very good question.
Whose name is Johannes something, registered.
Middle names and several middle names.
And you've got several hyphenated middle names and all of that. There's no statutory answer. I'm not aware of any jurisprudence. I think the safest course of business, course of conduct, is to ask for a certificate of immigration, citizenship, passport. Okay. I mean, when I argued the Wilson case, it was on the basis of some 18th century definitions of given name. So there's no statutory rules. I ask for that, and by the way, when you are the lawyer is being asked to perfect the security interest, you should qualify your opinion to your secured party that you've relied on thus and so. What I often do is I get a birth certificate, even for Canadians, I'll get a birth certificate and a statutory declaration, because of course you can change your name under the Change of Name Act. So I get a statutory declaration saying here's my birth certificate and it's accurate as of today's date. But there's no perfect way that I'm aware of.
How do you register under the name Van space something? Do you take the Van as being the surname, or do you take the Van as being a given name?
I always thought Van and De and that are part of the last name, the surname. And they will accept hyphenated surnames or two names as part of the surname box.
When you do the search back to you, they delete the hyphen.
They do this.
If you want,
Really?
the hyphen back, they give you 25 letters in the name.
Sometimes what I do too, by the way, I have an abundance of caution, where I practice in Ottawa, and the problem we have there is with the name Joseph. There's a lot of French Canadians there, and they're given at birth the first name Joseph. They never use the name. You ask them on a stack of Bibles what their first name is, they'll tell you it's Claude, and then, it's happened many times where after the bankruptcy, you ask to see the birth certificate and Joseph Claude. I was going to argue, I still may argue in court that Joseph is not a given name. It has religious significance. It comes from God. Maybe I'm not sure. I'm not Catholic, so I can't even rule on that. At the back. Depending on what, I'm sorry?
Let's say it was something sold for some additional sales contract, which did not say the security agreement that this is to become a fixie, but nonetheless met the definition of the essential.
Oh yeah, you don't have to say. Again, don't forget the section 2, which says doesn't matter what form you're talking about. No, you look at the definition of PIMSI. If in substance, in law, that's what's created, that title is reserved, or a security interest is reserved by the seller, you don't have to say this is a PIMSI. But, sorry, you're going to ask a supplementary. So depending on what because there's a timing requirement in terms of perfecting a security interest, a PIMSI. For example, it has to be registered if it's equipment within 10 days after the debtor obtains possession of the equipment. Okay, so if you've missed that, you get into all sorts of interesting scenarios here. If the security agreement is signed on day 1 and possession is not given until day 40, I think you have to register within the 30 days, because under Section 47.3 says you have to register within 30 days in order to perfect. Section 34 sub 3, I think, says that you can register before possession, but not after 10 days after possession, in order to perfect a PIMSI. So you may then have a properly perfected, if you're outside of the 10-day period, but still within the 30-day period, you may have a perfected security interest, but not a perfected PIMSI. So then you've still got some priority, but not the super priority. You have to look at all the wording. How many questions do you want me to take?
1 or 2 more.
Okay, 1 or 2 more. Young lady here. Okay. The question deals with bringing assets in from outside of Ontario, all I can do for the sake of brevity is refer you to sections 5, 6, 7, and 8 of the PPSA. I get that question probably twice a week because I act for Ford And they're constantly bringing cars in from, that are subject to their security interests, and I act for a couple of trustees. They get that every week in Ottawa. I didn't think the question would come up here in Toronto, being in the depths of Ontario. But it's a very complex question. For one thing, when you register, there's a little thing up here on the financing statement called a caution filing. The short answer is there is a requirement for the secured party, regardless of where he's located. Don't forget, conflicts of laws determines that it's the situs of the collateral, and our PPSA determines that it's the situs of the collateral that governs, and therefore if the car, as at the date of the bankruptcy, is in Ontario, then subject to certain exceptions, the PPSA will govern. And it then in turn says that if the secured party knew that the goods were brought into Ontario, then he had to perfect within, I think it's 15 days after he found out, and in any event he has to perfect within 60 days. Whether he knew or not. And so you get into some very inequitable situations where the secured party didn't even know that the goods had been brought into Ontario. Yeah. Same thing.
Same problem.
It's possession, not registration. It doesn't matter that the registration is in.
The registration, when a car driver or owner who is secured today, where's the car into the problem? It immediately changes the plate, changes the on the ownership paper. Isn't there an understanding that secured parties would be notified?
If he's not notified, then then it's too bad, basically. Yeah. Yes, sir.
Car dealer sold the car to an individual, puts the wrong name on the financing statement. Discovered this 8 months later. The lease payment, the payment's not in arrears at all. What right do we have to repossess that car? You know that actually being possession. If he took possession, would be the damages claimed by the owner. In fact, even against the trustee in bankruptcy, the trustee will argue there's no right to possession at the time. Therefore, there is no real possession.
Okay, you recall that I said that you cannot repossess after the bankruptcy because you can't take it out of the possession of the bank. Before bankruptcy, yeah, you can only repossess if in accordance with your contract or the PPSA you have the right to repossess. Yeah, no, it's only in the event of default that I'm aware of. If you think that he's going bankrupt, I'd repossess anyway and suffer the consequences.
Thank you very much, Martin. Our next subject matter, moving into the latter part of the bar admission course, is also default, whether under PPSA, debenture, Bank Act security, or mortgages. That's an area covering receivership. There are 2 chapters in your materials on receivership, and at the end of one chapter, particular page 141 and 142, is a schedule covering the differences between court and private appointment. Most of you, whether lawyers or accountants or trustees, will be representing not the receiver or the secured party that puts in the receiver, but representing others such as landlords, employees, tax bodies. And the rights and remedies, unfortunately, at least in this province, are not governed by any particular piece of legislation, but are governed by common laws that's being developed. And there's a whole body of jurisprudence that's now developed. This afternoon, we're privileged to have Alan Driver of Coopers and Lybrand. Alan is a member of the Canadian Insolvency Association. He's also a member of the Coopers and Lybrand National Insolvency Arm. Alan's been involved in many receiverships, and he's going to give you the viewpoint from the receiver and how it applies to receiverships, whether it's court, private, or whether under a particular secured document. Alan? You've got a slideshow too. Can we put it on now, or?
Sure. How far can I walk with this thing before I trip up? I'm fairly good. Okay. That's the base
Want it
here.
on now?
Yeah, sure. Why don't we have it on from the start? Good afternoon. Frank was kind enough to mention the Canadian Insolvency Association, and I will put in a brief commercial message at this point for the association. It's an association that's 9 years old, and it constitutes essentially a representation for people who practice in the insolvency area other than the members of the bar, although we have a few lawyers as members. And I would commend to all of you that if you ever have to pursue rights under security or in a bankruptcy, that one of the things you might check out in looking at who you're going to use is whether they're a member of the association or not. The chances are that they are, but it'll give you a little bit of an assurance at least. End of commercial message. I should also say that the Canadian Insolvency Association is more affectionately known as the CIA. And I guess 3 years ago now I was doing a seminar for the CIA in Halifax, Nova Scotia. And we flew into town at a time when they were presenting honorary degrees at one of the universities there. 3 of us arrived, including our executive director. We blithely walked into the hotel and said, "We're from the CIA and we want to check into our rooms." Everything went smoothly for about the first 10 minutes. And there was suddenly a rap on the door of our executive director's room, and there were 2 men with guns outside. What we didn't know was that the Prime Minister of the Irish Republic was receiving an honorary degree, and he was staying on the top floor of the hotel. The clerk had misunderstood CIA and checked our executive director into the room next to the Prime Minister's. And I guess when CSIS, or RCMP as it was then, checked him out, they decided he must be a terrorist. Fortunately, it didn't take much explaining because our executive director is Japanese, so they recognized he wasn't an Irishman, certainly not by any standard definition. I guess to start off with talking about receivership, receivership is one of those words, it's spoken in fairly hushed tones and fairly with negative inflection. So perhaps we should start with a definition, and at the beginning of the material, the chapter on receiverships, there's a definition here which I had to put onto a slide. Yeah, the right way around? Yeah. A little bit, yeah. And I should say all of these slides are in the binder you have there, so if you want to make notes on them as you go through, I know some people find that a convenient way to make notes. Lectern over. There we go. So receivership, and this is, I guess, a fairly restrictive and strict definition of receivership as a legal term to describe taking possession and control. In other words, a custodial and protective right which is exercised in certain situations. When the man on the street uses receivership, he very often means bankruptcy, which is something quite different. But when he does use the term correctly, he thinks of it in the modern context where you're talking about not only taking possession and control, but quite probably managing a business, selling assets, selling the business, and dealing with a myriad of problems. And today I'll be talking in that more broad sense. I should say that the majority of receiverships are simply things or events that flow out of the holding of a security interest. They're the general case to which I'll speak. The other or the other cases which can occur, and I guess they are not common, but they're frequent enough that they do occur, and are worth noting, are where you have a shareholder or partnership dispute, and neither party trusts the other to look after the assets. In some regulated industries, there'll be the regulator with a power to take possession. It's not always called a point of receiver, but in substance, it is a receiver. And then under the Bankruptcy Act, there is a provision for the appointment of an interim receiver, usually to take care of assets pending a hearing of a bankruptcy petition, or if there is a proposal under the Bankruptcy Act to put somebody in command that people can deal with while the proposal is being considered. Today, though, I will speak strictly on the security enforcement type of appointment. Perhaps next we can take a look at the common powers of a receiver. To start off with, you have to take possession of the assets. Then you have usually the power to carry on the debtor's business. You're talking here about a receiver and manager. The terms are